Okay, I don't know what's going on. So this is in the matter of the people of the state of Michigan versus Kelly Dwayne Moe, file numbers 24-21931FH and 24-22090FH. Everyone Underwood appearing on behalf of Mr. Moe, and Ms. Holly is present in the courtroom. So, Ms. Underwood, have you had a chance to speak with Mr. Moe?
I have, Your Honor.
So, Mr. Moe, you have had an opportunity to read and review the pre-sentence report.
Yes, I have, ma'am.
All right, and you've had ample time to discuss that with your attorney.
Yes, I have.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I am.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Not really, Your Honor. There's just a lot that Mr. Moe would like the court to understand about his circumstances. And that this started out with that he was not given his transfer papers to sign, and then transportation became an issue, a serious issue. He called and tried to resolve that, but he wasn't able to do it. And then he got in a situation where he was just scared. I mean, he didn't start out not wanting to complete this, not at all. Okay. And I think the probation report kind of makes it seem like he did.
Okay. Mr. Moe, is there anything you want to say? Are you here on Moe? No. What are you here for?
I'm not here for this one.
Okay. All right. I'm sorry. I was speaking to Mr. Hartung, a prosecutor, Mr. Moe. Sorry. All right. Mr. Moe, is there anything? All right. My computer is shutting down and restarting, and I don't know what's happening. Okay. So, Mr. Moe, is there anything you'd like to say on your own behalf?
The only thing I have really say on my behalf is this is the first time I ever had leniency.
I have more to say, Your Honor. I'm sorry. I have more to say to allocute for Mr. Moe.
You know what? I'm sorry, Mr. Moe. I really thought Ms. Underwood was done talking, but let's let her finish.
Thank you. Your Honor, this is Mr. Moe's first violation. It is a failure to report. It is not a new crime. It is nothing like that. I understand that Mr. Moe completed 365 days in jail.
Rhonda, stop for a minute. Stop for just a minute. Like, I don't know what's going on with my computer, and I'm sorry, but it's like, yeah.
But mine's doing the same thing. It keeps going black and back on. I don't know what's going on.
All right. I'm gonna call your brother. In IT. Hey, Derek, it's Judge Anselon. So I'm on the bench. My computer, Becky's computer, like this, it's almost like you're logged on and closing out all my screens and playing with it. So you think you could, and I'm trying to do sentencings, but I didn't know if you could like actually log on and see what's going on.
I think it's taking updates.
No.
Yeah, I seriously do.
How do I stop that?
I don't know if I can. I'm almost 100% sure that's what we're doing, because I did that yesterday.
Is it gonna enter? Do I just?
It will automatically, it'll finish, it'll stop blinking. Is the screen still like blinking on you?
It's not right now. So, yeah, because my peripheral screen would shut off. Oh, no, it just said the system has been updated.
Okay.
So I'm done?
Good sign. So yeah, it should be done.
Okay.
I can look, if it does it again, because there's a big display out there in the last update, so that's why it messes with your displays.
Is that why my Zoom's been acting up?
Yeah, probably. why Zoom is acting up.
I'll send you those screenshots. All
Yeah,
right.
that'll work. Do that and I can look at it, Judge, and I'll let you.
Okay, thanks. Bye.
Yep, no, bye.
All right, so my screen looks normal now, Rhonda. Proceed.
Thank you. Mr. Moe, I understand has done a great deal of jail, 365 days. I hope we can find an alternative for Mr. Moe to prison, Your Honor, because I don't think this Mr. Moe really belongs in prison for this violation. It's a first violation, and it's failure to report, Your Honor. That's what it is. So I know he has jail available on one file, and we would ask that whatever the court does, Mr. Moe gets full credit for all the jail he's done. I know there are two different jail amounts. One on the 10-year and one on the 4-year.
Okay, sorry, my computer just like did that thing it does again. Okay, so going up. So, he has 140 days jail credit on one file and 365 on the other still, Miss Holly, or do we have?
First violation is arrested. I need to buy my.
Joanne, we can't hear you now by mic. Can you scoot up by mic?
I'm sorry.
Thank
Plus
you.
whatever served for being this arrest. You got arrested on 10/7.
And I might point out that the recommendation is to the high end of the guidelines, Your Honor, for 3 years. It's more appropriate, I believe, if there is going to be prison time, that it be to the low end of the guidelines, Your Honor, which would be the 19 months.
So 16 days violation.
16.
Yes.
So in 24-22090, he's got 156 days credit.
Yes. Yes.
And then on the other file, he will have 365 plus 16. My computer's just like going on and on.
381.
Anyway. Okay, Miss Underwood, my computer keeps going on and off. It's not impacting what you see, does it?
No,
Okay,
everything looks totally normal on my knock on wood.
okay,
Same here.
thank you. Okay, great. All right, and there was $10,700. Look at this stuff. In restitution. All right, I'm sorry, it's just like flashing back and forth. All right. Okay, anything else, Miss Underwood?
No, Your Honor.
All right. All right, Mr. Moe, anything you want to say on your own behalf?
Yes, there is, ma'am. This is the first time I ever had leniency, ever been in trouble. I've never been on probation. I've always been sent to prison, on parole. That really has not helped me out. Probation, I know, is a lot stricter. It's more, and I didn't want to mess this up. I did call when I first got out. I did call again, say I don't have a ride. My sister's only ride I have is my sister. I'm not trying to call the people I used to hang out with. Hey, give me a ride. You're a felon. Give me a ride. I'm not trying to do that. I'm trying to be good. And I didn't want to mess this up. I really didn't. I was just going through I had a lot on my plate when I first got out. That's all I got to say.
Okay. All right. I mean, you've been on probation before because you've had probation revoked on different things.
Parole.
You did when you were younger. Your record's pretty long.
This is,
Um,
you can see the probation, I never last long.
now where's your sister living now?
She lives in Deconcha. And she never moved to Pennsylvania. I never said she moved to Pennsylvania. I said she went to Pennsylvania for a week. That was my ride. I won't have a ride for a week. And she insists that I come 2 days later. That no, I just told her I didn't have a ride till next week. And but she lives in Deconcha, Michigan, and that will be my address, Deconcha, Michigan.
All right. All right, it's a sentence of the court. You know, you've got out of jail and you just dipped out on us and we never saw you again, which you have kind of a history of doing, but we have pretty substantial restitution on this case. So that's a concern. And when you go to MDOC, you tend to get a lot of tickets. So, what I will do is on file number 24-21931FH, I'll give you credit for 381 days. I'll continue your probation. On file number 24-22090FH, sentence the court to serve 1 year in jail. I'll give you credit for 156 days already served. When you get out of jail, I don't care if you have to sit in front of the building the whole weekend to report to Miss Holly, you will. Otherwise, if we have to issue a warrant for you again, understand you will go to prison.
Yes, yes, ma'am.
All right, you owe $10,700 in restitution. I'm more concerned about that. I will say that if you pay the restitution of $10,700, you can be released from the Lenawee County Jail. I don't think that's probably going to happen, but if $10,700 is paid, you can be released from the jail. Otherwise, you'll serve the year with credit for time served and your probation is continued.
What's his address gonna be?
Yeah, what's your address at your sister's?
It will be 203 North Main Street, Deconcha, Michigan. 49.
Is concept
Concha.
CON, huh?
TECONSHA.
I don't get that. Why?
Teconcha. All right, so it's TEKONSHA, Michigan. Yep.
Okay, the zip code
49092.
and your phone number?
269 300 2382. That's her number.
Okay. Who's your sister?
Yes, that's my sister, Carrie Moe.
What's her name?
Carrie Moe.
Terry with the T?
Carrie. Kari.
Okay. Okay. All right. Understand if we have to hunt you down again, though, you will go to prison. So, so I would like you to get out when you're done and get a job and start paying down that restitution. You do have the right to appeal the sentence, so we're going to give to you at the jail 3 copies of your notice of right, 2 appellate review, initial and date, 1 copy for our records to acknowledge receipt of the paperwork. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Anything else, Ms. Underwood?
Your Honor, just to clear up, is probation only continued on the first file?
No, because restitution's on the other file.
Oh, okay. Okay.
Okay.
So I got
All
a
right.
year.
You got a year with your credit for 156 days. So, yeah, the guidelines are actually higher on the first file, Ms. Underwood. So I want them to keep on probation on that one. All right. Good luck to you. Thank you.
Thank you.
All right, my computer's not doing weird things. Okay. Underwood, is that all we had? You must be getting that extradition in front of Judge Olsever. She's gone. There's an extradition on a woman that committed a double murder. She's being extradited to Toledo. It's just unusual. You don't see that, so. All right, Mr. Fry, you have Mr. Steers,
Yes, Your Honor.
and I have Ashley Messer from the AG's office. Good morning, Ms. Messer. What is your P number for us?
Good morning, Your Honor. It's 76062.
Thank you. This is in the matter of the people of the state of Michigan versus Adam Christopher Steers, file number 25-22236F8. I have Brian Fry appearing on behalf of Mr. Steers, and I have Ashley Messer appearing on behalf of the Attorney General's office. Says the date and time set for sentencing in this matter. Mr. Steers, have you had an opportunity to read and review the pre-sentence report?
Yes.
Have you had an opportunity to discuss that with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that she has given you?
Yes.
He has given you. I'm sorry. Jen Walsh is, Ms. Teskey, are you here for Ms. Walsh? Sarah Teskey?
Judge, I'm here covering Jen on this case.
Okay, thank you. All right. So, Mr. Fry, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, not at the time that it was made, Your Honor. We would note that this pre-sentence report was made when my client was still incarcerated at Hillsdale County Jail. He's since been released and is employed now and paying his child support now. So,
Okay,
but obviously that information was known to the probation officer at the time.
okay. Ms. Messer, do you wish to explain or challenge the accuracy or relevancy of any information in the report with the update that he's no longer incarcerated, he's employed, and allegedly is making payments on his child support?
No, Your Honor. Thank you.
Okay, and do you have verification that payments are being made at this time?
Your Honor, I don't see that payments are being made to this file. This is an arrearage only file, and I can check and see if Mr. Steers does have other files. Perhaps if he's making payments, it's just going to those. Let me see. He does have 2 files, and both of them do have arrearages. It looks like there was a payment made 10/22/25, but it went to a different file, not to Miss Taphouse's case where she's a victim. So he did make a payment. It just didn't get applied to this case.
Okay, so here's the problem. Because you have active files, anything they're withholding from your paycheck is going to go to those active files. And you live here in Lenawee County, correct?
Yes.
All right, so my advice to you is you're gonna have to pay extra out of pocket on this file here in person,
Okay.
okay? Because you're gonna have to direct the payment because this is arrearages only.
Okay.
Do you understand? Please get close to the mic, sir. Yeah. Okay, so thank you, Ms. Messer. And, all right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. Fry?
I don't believe so, Your Honor.
All right, Ms. Messer?
No, Your Honor. Thank you.
Probation Department in this case has computed the minimum sentencing guidelines to be 2 to 17 months. Do you agree with that computation of guidelines, Mr. Fry?
So, Your Honor, obviously I was not Mr. Steers' attorney when he did his plea. There was a conflict with public defenders and I just took this over for this hearing. But when I reviewed the guidelines, we do have a couple of disagreements with the scoring.
Okay, hold on.
OB 16.
Slow down. Let me
Sorry.
get to the page. All right, so OB 16, property obtained, damaged, lost, or destroyed. So let me get there. So Ms. Walsh scored OB 16 at 5 points. The property had a value of $1,000 or more, but not more than $20,000. So I'm gonna guess your argument is because this is child support, it's not deemed property.
Correct, Your Honor.
All right, Ms. Messer?
Stipulate to that being 0, Your Honor.
Okay, So we will strike OB 16 as 0. So that will take his OBs to 0. And does that change his grid?
No, Your Honor.
Okay.
Change the grid, but
Any PRVs that you wish to dispute?
PRV 7, Your Honor, which is concurrent convictions. He did have 2 counts in this case, but count 1 was dismissed, so he only was actually convicted of 1 count. So there was
Was
no.
count 2 added for purposes of a plea?
No, Your Honor, I think he was always charged with 2 counts of failing to pay child support, and the plea agreement, as far as I'm aware, was count 2, count 1 was dismissed, so he was only convicted of that 1 count, which is a sentencing offense. There was no concurrent conviction, so we believe that that should also be scored at 0, and it's scored at 10.
Spencer?
Your Honor, I agree. The defendant pled guilty to count 1 and count 2 was dismissed. Perhaps this was just calculated as charged, but yes, he did only was convicted of 1 count. So OB 7 should be 0, or PRV 7 should be 0.
Okay.
I believe that changes the guidelines to 0 to 9 months, Your Honor.
Okay.
So, Your Honor, I'm changing PRV what?
PRV 7 will be 0.
Okay,
And OB 16 will be 0.
okay.
That makes the guidelines 20 over 0, 0 to 9 months. For guideline minimum range.
Okay.
All right, so we have made those changes. Mr. Fry, anything else with the guidelines?
Nothing further with the guidelines.
All right, anything else with the guidelines, Ms. Messer?
No, Your Honor, thank you.
Ms. Messer, is there anything you'd like to say on behalf of the Attorney General's office before the court?
Your Honor, if I
has-
could just, I'm sorry, Your Honor, I didn't mean to cut you off. If I could just inquire whether or not Ms. Taphouse is in the courtroom or on Zoom. She is the victim in this case.
Not in the courtroom, and she's not on Zoom.
Thank you so much, Your Honor. Your Honor, at this point, the defendant owes $29,738.22. As we've discussed with him, he hasn't made payments on this file in quite some time. It is an arrearage only case. He does have another active file, and as Your Honor already stated, he did make a recent payment. However, because that other case is charging, it went to that case. So I would just ask that he be placed on a term of probation so we can monitor his payments on this file, as there is quite a high arrearage. Thank you.
Mr. Fry?
Yes, Your Honor, we would ask that the court place my client on probation, monitor his payments. As we've discussed, he was incarcerated on this case. He did get a PR bond and then was immediately picked up by Hillsdale and was incarcerated there until September 22nd. So he's been out a month or so. Since he's gotten out, he is employed with Maxable. He did bring me a couple of his pay stubs here this morning. They have been taking money out for child support. You know, as he found out this morning, it's not being applied to this case apparently, but that's something that he can address going forward now that he knows, you know, that's being applied to a different case. But he is employed now. He is making child support payments in some cases, apparently a different case, but he can make an extra payment as the court indicated on this case now that he's aware. You know, but again, he is gainfully employed now, and you know, he is making child support payments, and he's prepared to continue to do that. Thank you.
Okay. Anything you want to say on your own behalf?
No, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and protection of society. It's sentence of the court to be placed on probation for a period of 3 years. During that term of probation, you will obey and comply with all the articles and provisions in your probation terms. So how many hours a week are you working?
40.
40, and how much you make an hour?
14.
14 an hour. All right, I'm gonna waive the $750 in court costs. I'm gonna order a $130 crime victim rights fee, $68 in state costs, $30 per month supervision fee, 60 if we have to put a tether on you. Okay. I don't want to do that. So your restitution obviously is your arrearage. You would have to make a payment of like $820 a month to pay this off
Right.
during the 3 years. Based on your income, the fact that you have a currently charging case, I recognize that that's not going to happen. You understand?
Yes, sir.
But I have had people pay it off. They, fix up cars and sell them. Like they do stuff. So, we're going to want to see a monthly payment made on this. And I know it's gonna be tough if you're paying that case and you're making 14 bucks an hour, but as long as you're paying something every month, like 100 bucks, 200 bucks or more when you can, that obviously will show that you're paying your other child support case and paying this, and that's a good faith effort. Let's see, you have 83 days jail credit. During your term of probation, I'm not. Let me see. License suspended. All right, so I'm not going to order alcohol terms because I don't have any indication in there that you have an alcohol issue. Just don't be stupid, right? Okay. No use of illegal controlled substances, obviously, because that's illegal. Complete any treatment as required. Report truthfully as often as required. Are you living in Hillsdale?
No.
Yeah, that's right. You live here. Report as often as required. Obey all court orders. Not to engage in any assaultive, abusive, threatening, or intimidating behavior. Let's see. You can't possess a weapon. Understand that they can come in your house at any time to verify you live there. And then if they believe you have items which could violate their terms of probation, they have the right to search your house, your car, your phone and things of that nature. Be truthful with them about police contact or job loss or moving, maintain employment. There's a $60 DNA fee too as well. Ms. Teskey, anything else? Do you want him to
No.
report Tuesday
No, Your
morning?
Honor. I would like him to report to Mr. Stevenson on November 4th at 8 a.m.
Mr. Stevenson's going to be his PO?
Yes,
All right, and that's November 4, you said?
yes.
So
At
2
8.
weeks from, so not next Tuesday, but the following Tuesday?
Yeah, I report to Mr. Stevenson, every second Tuesday of the month.
You know
Well,
what?
this is
Call him.
Right now.
Yeah, so do you report next week?
Yep.
All right, when you report, just talk to Mike about it. You guys will
Okay.
figure it out. He'll put you on the same schedule.
Okay.
All right, anything else, Ms. Messer?
No, Your Honor, thank you so much.
All right, thank you. All right, good luck,
Thank you,
sir.
Your Honor.
Thank
Can I have
you.
an appointment?
Oh, wait, you gotta sign your appellate rights.
Mr. Fine, Mr. Bennett will approach us for a minute.
Yeah, so you do have a right to appeal this sentence. So my bailiff's gonna hand down to your notice of right to appellate review. You got me nervous, you were congregating. So, you're gonna initial and date one copy for our records. If you wanna appeal my sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Ms. Messer, thank you. I'm gonna pop the courtroom in the waiting room.
Thank you. Have a good day.
Thank
Thank
you.
you, Your Honor. Thank you.
All right, the 14B District Court is now back in session. The court will call the case of Melvin T. Walls, Manor versus Roosevelt Boyd, case number 25C 3496.
Ellis Freakman for the
I'm
plaintiff.
sorry. 98. Sorry about that.
Ellis Freakman for the plaintiff, Your Honor.
Thank you. Mr. Boyd, please have them unmute you so you can state your name. Please state your name. You're unmuted.
Roosevelt Boyd.
All right. We're here for a continuation hearing in this landlord-tenant matter. Mr. Boyd, I understand you're going to be arraigned by the magistrate on a separate matter later today. Okay? The last we left off, Mr. Boyd, I believe we were waiting for your testimony. Am I correct, Mr. Friedman? You agree with that?
Yes.
All right. Mr. Boyd, do you still want to testify in your case? Can you please scoot closer to the camera? Can you
Huh?
scoot closer to the desk, please, sir? All right. Now, did you want to testify, sir?
Yeah, I guess so. I just about done said everything, you know. I repeat myself practically, but I still speak up.
Okay. So I know you testified that you were baking marijuana. It's
Yes.
my last notes indicate.
Hmm.
And that you weren't actually smoking it. You testified you didn't smoke in the building, is that correct?
Never
Okay.
smoking beer. I leave out of my building all day long, 3, 4, 5 times a day. I have plenty of
Okay.
time to smoke
Before
all
you
along.
continue on, please raise your right hand to be sworn. Do you swear or affirm that the testimony you have just provided and the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. All right, you may proceed.
I'm saying I never smoke in the building. I go out enough to smoke while I'm gone if I were going to do that. I never smoke in the building. And my girlfriend do not live with me. She been visiting me. He told me that she had 15 days. Well, after 15 days was up, she stayed away for 4 or 5 days and she started visiting me again. So we figured that it probably lap over to another 15 days or whatever, but he said she got to go or couldn't stay there, couldn't be there or whatever. But she visited me, she don't live there. And he made a bad remark last time. I didn't like that. I'm gonna tell her to stop smoking crack in the back of my car. She do not smoke crack in the back of my car, and he ain't seen her smoking no crack in the back of my car. And I wish he'd stop lying on me. And then when the police come and arrest me, they left my door open. I told them to lock my door. He come up there and said he went in. He had no business. He been doing that ever since I've been there though. But he ain't got ever since he been there. He ain't got no business going in my apartment unless I say so. He had the opportunity to come up there when the police told him why they was coming. He had the opportunity then to come up there and investigate or whatever he wanted to do. He gonna wait till we leave and then go up there until he see the door open. He went in. And he smelled smoke or something. He sent me a letter saying that. We wasn't there long enough to smoke anything. Nobody wanted to smoke anything. We went in arguing. We come out arguing. We didn't have time to smoke nothing. We really didn't have time to even sit down. I kept going back and forth out the door, telling her to leave. She didn't want to leave. So I told her she'd go back in the door again. I was going to beat her ass, which I wasn't. Never hurt her, never hurt no female.
Mr. Boyd, sir, some of the things you're saying can be used against you in a criminal matter. You understand that?
No.
Okay, well, I'm telling you, you have a right, Fifth Amendment right to not testify and incriminate yourself. You understand that?
Yeah, I understand that, but I don't say I incriminate myself.
Okay.
I don't understand that.
I cannot give you legal advice, sir. I only can tell you what your rights are.
Good. Well, anyway, I don't smoke in the building. That's the bottom line.
Mr. Friedman, do you have questions for this witness?
Yes, Mr. Boyd, when we had our informal meeting at the
I apologize. Could everyone please stop for one moment while I reset the recording? I apologize for interrupting. I'm so sorry. One moment.
All right, we're back on the record. You may proceed.
When we had our informal meeting, you had an attorney with you. You indicated that you baked marijuana in your oven and used and inhaled the fumes of the marijuana that you baked in your oven. That's what you said, isn't that correct?
That was his statement. I inhaled it out the oven. I ain't said nothing like that. And I don't know how you got that from me. You didn't hear me say that. You heard him say that.
Who's him?
You heard Mr. Eric, or whatever his name, say I stick my head in the oven. I ain't said about stick my head in the oven.
Isn't it true that's what you told your attorney that you did?
No, I didn't.
And you were
trying to make up something. You can get off of that.
Mr. Boyd.
Y'all lying ain't what's the darn no way. Y'all know this is irrelevant. It don't make sense. All y'all had to do is just say, I forgive you, don't bake no, nothing, don't bring it in here, just keep it out of here. We'll give you another chance. That's all you had to say. You ain't got to go this far with this. This ain't that big of a deal, no way. I wasn't smoking in the building. That's point blank.
Mr. Boyd, you got multiple notices from management to stop smoking.
I don't care how many notice I got. I say I don't do it. That's what he say.
Well, you just admitted that you just wanted us to tell you to not do it, and then you wouldn't do it.
I
But we
say
told you
y'all
4
could have
times,
just
didn't we?
said that in the first place. You had to come this far with it. You could have just dropped this and went on and let me pay my rent. That's what I'm saying.
And Mr. Boyd, isn't it true that you agreed to vacate the premises within 45 days?
Getting back to that, we done did that already. I decided to change my mind. You got a problem with that? I wanted to be heard by the jury. You got a problem with that?
I'm not answering your question, sir.
I don't care. I don't have to answer yours either, then, do I?
You do, Mr. Boyd. So first of all, Mr. Boyd, I'm not even gonna say that yet. Mr. Friedman, you may.
I know I got an nasty
I don't-
attitude, Your Honor. I apologize, but I've been catching a lot of hard time on this case.
Your Honor, I don't have anything further I want to ask this witness.
upset.
He's just hostile. It's not worth me asking many more questions.
Mr. Boyd, you have acknowledged that you do bake marijuana on the premises, correct?
Yes, a couple of times, yes.
Mr. Boyd, I think the problem here is that you have decided to base your actions on a technicality. Even if I were to believe you that you aren't smoking it, the baking of it is causing an issue for other people on the premises.
And I ain't heard nobody else complain about it. That's what they saying.
Okay.
Ain't nobody said nothing to me about no smoking, but them.
All right. Thank you. Mr. Boyd, do you have anything else you'd like to say before I go back to see if Mr.
No,
Friedman
ma'am,
has?
I don't think there's nothing else I can say.
All right. Mr. Friedman, anything else you want to say today, sir?
Not today, Your Honor.
No further witnesses.
I just would ask Mr. Temple if he would just, if I could have him sworn.
All right. Mr. Temple, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may proceed, Mr. Friedman.
Mr. Temple, when Mr. Boyd was arrested recently, he was taken away by the sheriff's department. Did you go up to his apartment to secure it, make sure there was nobody else in it?
Yes, we did, based upon the police saying that they didn't have a key to lock the unit.
He had my key. I gave him my key. I told him.
Mr. Temple, when you went up to secure the unit, what did you see or smell or hear?
We smelled the use of marijuana, and that was after they took the young lady out, because they took him first and they took the young lady out.
Okay, I don't have anything further, Your Honor.
You have any questions for Mr. Temple, Mr. Boyd?
Talking to me, yeah?
Yes. Do you have any questions for Mr. Temple?
No, I don't have no question for him, but I didn't tell him he lying. I told him I wasn't, and you can play the tape back while we were walking up down the hall.
All right, Mr. Temple, one moment. So, if you don't have any additional questions, I'll allow you to testify again, but I want to keep it to this witness until we're there. So no questions for him. Is that correct? You have no questions for him, is that correct? Mr. Boyd?
Oh, you talking to me?
Yes.
I don't have no question for him, but I was saying something.
I understand that. So having no questions for him, then if there's nothing further from you, Mr. Friedman, Mr. Temple can be excused. Is that correct?
Yes.
All right, thank you. What is it that you'd like to say, Mr. Boyd?
what did he say? What was it? I was answering what he said. I forgot what he said. Anyway, I wasn't supposed. Oh, I was finna say you can see us walking up and down the building. We was arguing when we got out of the car. We went in arguing, and then we wasn't in there long enough to really sit down good. We up and down the hall, up and down the hall. Every time I try to leave, I'm going with you. I said, I'm trying to get away from you. I'm not trying to want you to follow me. So I turn around and go back. She go back. I said, you go back. I'm trying to lock the door so we can leave, I can leave or whatever. But she kept going back in the building. I didn't want her to go back in the building. I wanted her to leave. So I told her she'd go back in there again. I was going to beat her so-and-so. So I touched her on the back of the shoulder. That's all, lightly, mostly a push.
Sir,
And then,
sir. Once again, anything you say can be used in a court of law against you. And that can be used in your criminal case.
I ain't never been through this kind of stuff. I don't know what to say and how to say it, but the truth.
Well, all he's talking about is whether or not he secured the building. You're the one who's talking about your criminal case.
I'm talking about going in and out of that building, me and my girl. We wasn't in there long enough to smoke nothing. That's the point I'm trying to make. We wasn't there long enough to sit down talking about smoking. And then he said she come out the building with a cigarette in her hand, in her mouth or something. She never do that. She didn't even have no cigarettes. He said he smoked cigarette and marijuana. That's a lie. She didn't have no cigarettes at all.
Your statements today are acknowledgement of violating my orders in a different case to have no contact.
Well, I have no contact with her.
Okay, yeah. All right. Anything else you want to say, sir?
No. Well done. But when the police come up there, he let the police know that I was the only one on the lease and that she wasn't supposed to be there. He made that obvious to the police officer. So it's obvious that she didn't live there. And I shouldn't have really been put out of my own house because she come in there raising sand with me. I didn't raise no sand with her. I tried to get her to leave. She the one insisting on sticking with me and hanging with me. She mad at me because I wouldn't give her no money. Truth is the truth.
Okay. All right.
And why would I go in the house and smoke marijuana? I just got out of my car. I could have smoked my marijuana on the way home. He lying, like I said. Point blank.
Anything else, sir?
No.
All right. Mr. Friedman, his case is over, your case is over, or did you want to have anything to say to me?
Your Honor, I've made arguments throughout the case, summarizing my position up one side and down the other, frankly. And I don't think I need to belabor the points I've already made, and I don't think I need to waste the court's time with repeating myself. So no.
All right, thank you. Anything additional that you want to say today, Mr. Boyd?
Me?
Yes, you are Mr. Boyd.
I didn't understand the name you said. No. I haven't.
All right, the court took testimony in this case back in September 10th, and we continued the hearing or attempted to on a number of occasions. One time it had to be adjourned because Mr. Boyd's Wi-Fi system wouldn't allow him to testify. And then after that, I think the parties are aware that the court had an emergency in the family and had to adjourn the matter out several times. The court has heard the additional testimony from Mr. Boyd here today, as well as from Mr. Temple. The issue in this case is pretty straightforward as to whether or not the acts, whether as alleged by Mr. Temple, which is that he had been smoking marijuana on the premises, or the acts which were admitted by Mr. Boyd, which is that he has been baking marijuana in his oven. amount to a lease violation for which he can be terminated. The court had a chance to review the lease pretty extensively last night in getting prepared for this particular hearing. It is very clear in the lease that one of the ways in which an individual can be terminated is based on the fact that the activities, any act, whether it's smoking of it or baking of it, any act can amount to a terminationable offense. And in this particular case, Mr. Boyd has received numerous notices regarding the fact that the smell is a problem. In addition to that, the documentation showed that there were many notices about the fact that the fire department had to be called on numerous occasions, and Mr. Boyd's behavior around the concerns and safety of the other individuals in the premises has been a problem for a long time. It appears that none of those particular issues have been addressed, and that in addition to that, Mr. Boyd had a hearing whereby he had an attorney. The lease provides that he can request a hearing with the management to go over these issues and to try to reach a resolution. Mr. Boyd has not denied that. He actually acknowledged that he was going to move. And then he testified before, not today, but at the previous hearing on September 10th, that because he wasn't able to find a place to move, he didn't move. You can't just change your mind, Mr. Boyd. If you decide that you're moving, you agree to that. You've simply made a decision that you're moving. You can't just say, I'm not going to move anymore.
So I tried to move. I didn't say I was going to move. I can't say I was going to move, didn't know where I was going.
Okay.
I wouldn't tell nobody that. I ain't going to tell nobody what I'm going to do, no way, when I don't know what I'm going to do.
Well, the bottom line is he did agree to moving per statements by Mr. Temple. And in addition to that, his acts of continuing to bake marijuana is a violation of the lease, whether he's baking or smoking. And the court finds that you're in violation of your lease. And I will grant the possession judgment in this case.
Thank you. I'll file it.
Thank you. And I will give him his standard 10 days.
Thank you.
Thank you. The court will call the matter of 136 Group LLC versus Jonisha Henderson, case number 25C 3600.
Good morning, Your Honor. Good afternoon. For the record, Neil Chanis appearing on behalf of the plaintiff.
Hello.
Hello, please state your name.
My name is Jonisha Henderson.
Thank you.
No problem.
All right, we're here for the continuation of this hearing. In this particular matter, we adjourned it last time we started the hearing and had to adjourn it. And I apologize to everyone that we've had to adjourn it a number of times. The court has a family emergency that it has been dealing with for several weeks. I'm still in the midst of it, to be honest, but we are here and we're ready to proceed. And we adjourned this, so I know that Ms. Henderson had exhibits she wanted to submit, and she did submit them to the court. Have you received them as well, Mr. Chanis?
I believe it was a picture. Was that what was?
It was a couple of pictures and weather report.
Oh, I did receive those, yes.
All right, thank you. And then, Mr. Chanis, I believe that you had some witnesses that you wanted to bring.
Well, yes, I see that the witnesses that have already testified are present, but I was expecting one more witness who was, I think, going to have to call in, but I don't see that she's on the screen, so I don't know if she has appeared. Doesn't look like it.
The recorder, I'm going to chat with her right now to see if, I believe everybody, well, let me see, I can see myself. I think all participants are in here. There is no one in the waiting room.
If I can I put myself on mute for a second and just make a quick phone call?
You may.
It'll be very quick. Thank you.
You may.
Is there a phone number to call in lieu of zooming in that puts her into the Zoom meeting as opposed to the court's phone number?
The landlord can, the recorder can give you that phone number. It'll take her a minute to find it, I believe.
Okay.
Ms. Sean Isom, I need for you to raise your right hand to be sworn.
Yes. What's up?
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand.
Okay.
All right, Mr. Chanis, you may call your witness.
Thank you. Sean, please state your full name.
My full name is Chandala Isom.
And can you give me your address?
My address is 2958 Washington Road, apartment 1B, and that's in Ipsy.
And you are the apartment directly below the defendant, Jonisha Henderson, correct?
Yes.
And can you tell the court what you have experienced as it relates to the dog and the apartment upstairs, and how it is and what's taken place?
Well, since she moved in, I have been experiencing a problem with the dog urinating on the balcony and it coming down onto my patio. And more so, just one time, fecal matter kind of rolled over the side of the balcony down onto my patio, which it is still on the table right now because I didn't clean it off or nothing. I just didn't touch the stuff anymore.
And so, go ahead.
No, I was just going to say I did speak to her mom about it.
And you made her aware of what took place?
Yes, and she told me she would take care of it. She would talk to her daughter and have them walk the dog.
And just so you know,
So
there
I
was...
left it alone after that.
Okay, there was testimony from the defendant that the slats on the balcony above you were too thin for what you said fecal matter to go through the
Yes.
her balcony onto your porch. Can you explain
Right.
why that's not the case in this situation?
Well, the thing is, it is, they're too close for that. So what the problem is, I don't know if the puppy himself was up there playing or they actually swept it off. I don't know. But it rolled over the edge of the balcony, not going through. The urine is what's going through continuously.
And when you say continuously,
And,
how many times has this happened?
multiple times.
And to your knowledge, that dog is there all the time?
Well, I didn't hear him yesterday, but I was out yesterday. But the day before, I did hear him up there. I think him and the baby was playing.
Okay. Okay. I have nothing further at this time, Your Honor.
All right. Ms. Henderson, I think you remember the rules from the last time we took testimony, but at this point in time, you have the ability to ask any questions that you want to ask.
Yes, you said your name was Shine, right, Miss Shine?
Yes, my name is Sean, baby.
Okay, so I have a question. When I came to you about your downstairs patio, about your downstairs action after the rental office came to me and I asked you, was any of your property tore up? What was your answer to that?
No.
You said none of your property was damaged, right?
I said none
that's the
of my
question.
property was tore up. None of it is tore up.
Well,
None of
damaged is what, okay. So my next question is, when did you speak to my mom? When did you speak to my
I
mom?
spoke to your mom. It was just when the weather was finna break. It was still kind of cold out. I can't remember the exact date. But it was around the time she told me that anytime that there's something going on, instead of going to the office, let her know. So that's what I did. And she said she would take care of it.
That's oh, I can't testify. Okay. My next question is: you said you heard a dog yesterday. You heard
No,
her?
I didn't hear the dog yesterday. I
Oh,
didn't
the
hear
day
the dog
before yesterday?
I didn't say that.
No. When did you say you
Yeah.
heard the dog?
The day before.
And
I
you
think
quite
they was
frankly,
playing.
are you sure? And you sure it was a dog? Cause you sure it was a dog? Are we positive that it was a dog that we heard?
Yeah.
Okay. That's all the questions
My
that I
daughter
had,
was
Your
on
Honor.
the phone, but she's not here to testify. But she was on the phone. She was like, "Mom, I
Because
can
I
hear the
need
dog
my
barking." I
All right,
said,
you can't
"Yeah."
testify to what someone else said, ma'am, okay?
Right, I get it. I get it.
That's all the questions that I have.
Okay. Do you have questions, Mr. Chanis, based on those questions?
Quickly, Sean, how often do you see the dog?
I rarely see the dog.
How often do you hear the dog?
Well, like I said, the only time I didn't hear the dog was yesterday, but I was out, so I didn't hear the dog.
How
but
often?
I typically hear the dog all the time.
And
I
how
hear
how
the dog
recent?
all the time.
How recent would you say that you've heard the dog?
Not yesterday, day before.
Okay.
Yeah, I think him and the baby was playing. That's what I assumed.
Do you believe
All right.
that dog
You
is there?
can't speculate, ma'am. So I'm going to strike that.
Yes, I heard the dog. Yes, I did.
Okay.
So, ma'am, when you say you heard the dog, go ahead, Mr. Chanis.
Go ahead, Your Honor. I think you were. Go ahead.
When you say you heard the dog, can you describe what you heard for me, please?
Barking.
Oh, you heard the barking.
Barking. I heard barking. But you know, the little patter, pitter, patter. I hear the feet. Now that I think is the baby. And I think he's playing with the dog at the time is what I'll be thinking. You know, and then you could hear the dog barking, like, you know, they running around and stuff.
And so you heard the dog you heard the dog barking day before yesterday.
Yes, I did. Yes, I did.
And-
Very clearly,
and
I heard the dog.
And it's your testimony that you hear the dog most days in the apartment above
Yes.
you? Okay.
Yes.
And let's go back to the urine. When is the last time you had the urine issue on your patio?
It's been a while, but let me go back to the exact date. I'm gonna pull up the exact date.
Okay.
Hold on, let me pull up the exact date. It's been a while since this has been going on. Where's that? And the reason I know the exact date is because I made a video and uploaded it onto TikTok about the dog urinating on my. The date is, what's that, May? June 2nd was the day I made that video.
June 2nd. So that's the last date that the urination.
That I have documented, that I have noticed it. Yes, June 2nd.
Okay.
That I have documented that I have seen it. Yes, that's the last date.
All right. Thank you. I really appreciate that. All right. Any further questions, Mr. Chanis, based on my questions?
Nothing else, Your Honor.
Ms. Henderson, any further questions based on my questions?
Oh, no, ma'am.
All right. Thank you. Thank you for attending today and testifying, Ms. Isa. We appreciate it.
No problem. Okay.
You may
So
be
I can
excused.
go?
You're free to leave. Yes, ma'am.
Okay, thank you. Bye-bye.
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 All right. Any further witnesses? Mr. Chanis?
No, Your Honor.
All right. Ms. Henderson?
Yes,
I know
ma'am.
we did all this last time, but is there additional testimony that you'd like to give at this time?
Yes, ma'am. For one, I still don't have my dog here now.
All right.
There's two dogs that stay.
1 second, please raise your
Oh.
right hand and be sworn.
Yes, ma'am.
Do you swear or affirm that the testimony that you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. You may proceed now.
You're on mute.
Come on, John, leave it alone. Now, for one, the dog still ain't here in my house still to this day. Okay? Now, across the hall from me, my neighbors, they have 2 dogs. But we steady saying, because we hear dog barking, that is coming from my house. It's insane to me. Because literally across the hall from me, that's literally not even 10 steps, Your Honor. It's 2 dogs that stay there. But we saying that I have a dog. Me and my kids see these dogs every day. My baby be wanting to play with the dog because his dog is not here. He hoop, holler, and scream when he see that dog. That's why I sent him with my mom, so he could spend time with his dog. So it's crazy to me that we hearing a dog and we saying it's coming from my apartment. So that means I just got this dog now trapped in my house using the bathroom inside my house, not on the patio, but inside my house because he can't go outside because they didn't want him on his premises. This is crazy to me. I'm really, so what? It's still no dog here. Still, the dog is with my mama still. That's why I want my mom to testify. Because at this point, it's crazy to me because her and her landlord can even testify because I want her to get the paper from her landlord because they asked my mom to put the dog on her lease because he can't stay there without him being on her lease. So it's crazy to me that the dog been there all this time and they want her to add him to her lease. But we saying that my dog is here. I don't understand that at all. That's crazy to me. Stop, booty. Hold on. And then another thing. My dog don't use no patio. Now, Mr. Channing sent me a video of her stating that the baby was throwing a cup of water. She said kids, but really it was a kid because it was my 1-year-old that sits up and dump out his cup. My dog, when my dog was here, my dog ain't using no bathroom on no porch where we literally sit, play, and do arts and crafts at. My dog's not doing it. And then sweep and poop off the side of the porch is crazy to me. But that's really insane to me. This is all insane to me. It's diabolical. It's insane. The dog still ain't here. Haven't been here. We hearing the dog, but we ain't seeing the dog. So that means I'm letting this dog use the bathroom in my house. This is crazy. No, ma'am. Sorry. No. Now, my neighbors, we hear that dog all the time. We do. Me and my kids. That's why my son want to play with it. Yes, ma'am. But that dog is 10 times bigger than my dog. So that bark is really, the bark is even different than my dog. My dog is a little Yorkie. That dog is I don't know, it's a big dog. So no, again, we don't hear no dog coming from 2958 apartment 2B. No, we do not. It's crazy. The lies is crazy and I'm done, Your Honor.
Thank you. Mr. Chanis, any questions for her?
I do not, Your Honor.
All right. Well, Mr. Chanis, just so that you know, obviously one of my issues, I got a couple of issues and I don't know if you can address them.
Sure.
And I'll start with the most pressing one. The last documented issue regarding causing the dog peeing, even if I were to believe the allegation, was on June 2nd. And you gave her notice to rectify it, and it sounds like it's rectified, even if I were to accept that that's what was going on.
I understand. And I don't, the testimony speaks for itself, Your Honor. I don't have anybody else that can testify as to any occurrences after what Ms. Issam testified to.
All right, and nothing, you don't want to have, no further statements from you, Mr. Janice, is that correct?
I would just like to, if I can just ask either Alan Parker or Derek Taylor a quick question regarding the animal being on the property, then I would be done.
All right, I believe that my notes indicate that, let me see. Sorry, I'm using my phone to pull up notes.
That's okay. I believe it was either Derek Taylor or Alan Parker that testified that they had seen the dog being walked on the property fairly recently.
Alan Parker testified that he saw the dog get out of the car and was walking around the apartment with a child, 6, 7, or 8, and go into the apartment. The day before that testimony, which was on October 1st, so it would have been September 30th.
Yeah.
All right.
I don't need to, you have that information. I don't need to have them restate it.
All right, thank you. Anything else?
Nothing else, Your Honor.
All right. So, Ms. Henderson, anything else from you, ma'am?
I don't know. No. Yes, it is because I don't know what to say and what not. I don't know, but I find it weird. I don't know exactly what to say, but I went down there and asked the neighbor downstairs, well, after they gave me the paper about everything that was going on with the dog, and she said, "Oh, ain't none of my property being damaged." She told me that that this is hearsay, but that the maintenance man told her it was yours. But now we're saying it's yours.
Ms. Henderson, you
Yes,
cannot
ma'am.
testify as to what somebody else said. Okay.
Okay. Oh God, yes. Again, okay. I'm just saying we've been told what to say, but okay. I don't have nothing else to say.
Okay.
Nothing else to say. Thank you.
You're welcome. All right. So the onus, the burden is on the landlord to prove their case by a preponderance of the evidence. And the court has, quite frankly, been kind of torn on this particular case. And the reason being this, it's sort of a compounded situation. One, there was a point in time when the property manager did in fact accept payment for her to have a dog on the premises. But then it turned out that she didn't provide the necessary documentation to be able to move forward with having that particular animal on the premises. But at no point in time did I hear testimony regarding her being notified. You can't have that animal on the premises. Go ahead.
Well, there is the pet policy that has been provided to Ms. Henderson. There's also the rules and regulations that I provided to the court that clearly indicate that it has to be entering into an addendum to the lease regarding pets. That's required. The lease agreement speaks to the rules and regulations. She did sign those rules and regulations and was also provided a copy of the pet policy. So while she was told, while she may have paid the $150, maybe it wasn't verbalized to her. Maybe Mr. Taylor can speak to that, but the documents were provided to her and signed by her. The defendant, Your Honor.
Yes, I'm familiar with that part of it. But she also paid a fee that was accepted. And at no point in time did anyone say to her, "I'm applying that to your rent and you don't get to have the animal." I asked that specific question. So that's a confusing scenario. When you compile that with the fact that the last documented evidence of this dog causing any issues is back in June, I do not see where you're proving that this is a continuing health hazard. That's what you have to prove, that there's a continuing health hazard. I don't see that here by a preponderance of the evidence. And I understand that someone said the dog was on the premises on September the 30th. My notes clearly show that. I went back and looked at all of those. And I'm aware that someone is saying the dog was there on September 30th. I'm also listening to the tenant who's indicating that, the downstairs tenant, Miss Isom, who's indicating that that she hears dogs upstairs. And the question becomes, if someone is right above another person, it sounds like they would be hearing the dog that's upstairs, right? But she's also testifying she's not seeing this particular dog. So I don't know how big the dog is next door, but this particular witness, Miss Henderson, you can shake your head all you want, Mr. Taylor. I get to make the decisions. Miss Henderson is testifying that there's a dog next door. So the bottom line is, you want me to put her out because of a continuing health hazard and a violation of the lease. That has to be proven by a preponderance of the evidence, and I'm not there for that. Now, it doesn't stop you from bringing a new case whereby you can fully document that this dog is on the premises, document and bring in the other witness from next door to say that they've seen the dog or whatever it is that you want to do. But at this point in time, I'm not convinced, and I'm not going to grant your judgment. So it's going to be denied. So if you want to bring a new case, I will certainly take into consideration everything that was said here today and back in October. But at this point, I'm not convinced of it. Okay?
Understood.
All right. Thank you.
Are we all set?
You're all set. Have a good day.
All right. Have a good day.
Thank you.
And Mr. Pravatsky, you had filed a motion back in August, I believe, regarding subpoenas. Is that right?
Yes, Your Honor. I believe I have enough information in my exhibits, but I wasn't sure if you would require anything further that might provide more evidence.
Okay. Well, yeah, you're going to make the choice as to whether you want to proceed with the discovery or not. What I'll tell you is I won't authorize subpoenas. That's under small claims statute. That's probably a more elaborate discovery than normal. I would allow you to file requests for productions if you believe you have more information. And as you know, you carry the burden of proof in this case. So if you want to do requests for productions, we're obviously past the 60-day limit for doing that. But since the court didn't schedule it, even though you were supposed to ask us to schedule a motion hearing, that's why you never had one. I'm willing to reset it to give you time to do the request for productions. So you tell me, do you want to proceed or, pardon me, or do you want to do your request for productions?
I appreciate that, Your Honor. I feel that enough time has passed in this case, and I'm hopeful that I have enough evidence from what I was able to find to be able to convince you and provide the basis in law that that is enough to prove their misrepresentation. So I would like to proceed, Your Honor.
Okay. All right. If all three parties would raise your right hands for me. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
I do.
I do.
I do.
Mr. Lynn? Mr. Lynn, is that a yes?
Yes.
Okay, there we go. Thank you. And Ms. Kish, on behalf of Lowe's, what's your role there?
I am representative, but also in-house paralegal. I handle all of our small claims.
Okay, thank you. And Mr. Lynn, on behalf of iSpring,
I am representative, but I am an office manager.
Okay. Are you counsel? Mr. Lynn?
No,
Okay. So you're not an attorney?
no.
Okay, and Ms. Tish, you're not an attorney?
Correct, Your Honor.
Okay. All right, Mr. Pravatsky, go ahead.
Your Honor, here seeking over $9,000 in damages for Lowe's and iSpring's deceptive sale of a water filtration system that elevated my water pH to dangerous levels without disclosure. It involves a clear chain of causation from iSpring and Lowe's deceptive practices to significant economic harm. The deception on November 27, 2024, I purchased an iSpring WCFM 500K water filtration system from Lowe's after consulting with iSpring about my well water, which had a safe pH of 7.88.
Okay, so hold on. So at the time you purchased the filter, your pH was what?
7.88.
Okay. And you consulted with iSpring, why?
Just to make sure, water's important to be right. I consulted with them via their chat function. I'd found them after a search and thought, oh, that looks like a good system. It seems like it'll meet the needs. But I chatted with them just to make sure and provided to them the information about my well water, the specifics of its, what do you call it, chemical composure.
Okay.
And that day when I purchased the product, which is my Exhibit 4, it showed no warning on Lowe's that this system would dangerously elevate pH levels, nor did iSpring say anything about that. And then the discovery, so after their professional installation costing me over $3,200, my water pH spiked from 7.88 to 9.59. And that far
when was that
exceeds.
reading? When was that reading?
Let's see. That is in the report. And the report is dated, is this the right one? Yes. February 21, 2025 is when the request was made for water filtration testing through Simple Lab.
Okay, and you purchased it on the 27th of November, is that correct?
That's correct, yeah. And
when did you install it?
The installation date was on the receipt here. Installation date was December 19, 2024.
Okay, and then 2 months later, you're seeing a high pH.
Right, and only because we'd started to experience some issues with our water heater did we retest the water. Normally, you only retest your water kind of every 6 months on a well, but I retested it earlier, specifically because we were having issues with our water heater.
Okay.
And so it made it 959, which is far above the EPA's maximum of 8.5. Washington also sets a standard of 6.5 to 8.5. And then when I complained about it in April of 2025, after receiving that report, doing a little more research myself, then Lowe's and iSpring suddenly added a pH warning to their product website 5 months after my purchase. They in my exhibit 10 in the email with Lowe's, they admit that it was posted the day they received my email. So that's a retroactive disclosure proving they knew or somebody knew about the pH risk but failed to warn consumers. And then Lowe's actually provided you an Exhibit D3, which is the EPA standards, which also proves my case. If you look at page 4 of that, it shows that the pH maximum is 8.5, and a high pH will cause deposits. And then page 3 goes on to explain that it causes economic impacts, restricting or even blocking water flow, in turn causing the economic damage that I had to replace my water heater well before its useful life. It was just under 7 years old, and it has a 25-year warranty. So it just tells you how much more useful life it would have had. And then that resulted in the cascading damages. So the high pH damaged the tankless water heater. And then I had to remove the iSpring system. So that was $1,900. I had to replace the damaged water heater, which was another $1,800. And then I had to install the replacement, which is another $2,000. And all those costs are directly traceable to the undisclosed pH hazard. And so this isn't speculative, Your Honor. This is exactly what the EPA says might happen if with high pH water. And Lowe's actually provided the document that proves it. I provided also my water heater manufacturer's warranty, which basically says they don't cover it or excludes it when the water with high pH levels is run through it. So as the same point, high pH is not good for anything in your house. I don't know if it caused further damage beyond that, but I know for sure that it damaged the water heater. I made plenty of good faith efforts to resolve this, Your Honor. Before filing it, I attempted conciliation through the DRC. In that iSpring was non-responsive to DRC's repeated outreach attempts. Lowe's actually confirmed to the DRC that iSpring controls the product specifications on the website, or either that or in an email to me. Sorry, Your Honor, I don't remember which. But Lowe's allows iSpring to put, it sounds like to me, on their website whatever iSpring or these third parties want to. And then there's a public safety validation. The U.S. Consumer Product Safety Commission published the hazard report. So I filed the report with them. They review it, from my understanding, and then they published it, case number 516-0705, my Exhibit 9, confirming this is a genuine public safety issue. So, Your Honor, I'm asking this court to hold Lowe's and iSpring accountable for selling a product with undisclosed safety risks that caused over $9,000 in documented damages. I mitigated my losses by not including the $3,000 I spent on installing a replacement filtration system, or the cost of that, because that's what I was looking to do here in the first place anyway with their system. But if not for purchasing and using their system, I wouldn't have had all the damages that I've outlined for you.
Okay, so the damages you're claiming are the $5,700 in removing, replacing, and installing water heater?
That, as well as the initial installation of their system, which was $3,200, $8,240. Then the remediation, removing their system, which cost $1,949.61. And then the replacement water heater, which was $1,819.67.
Okay, so do you have your damages spelled out someplace in your material?
Your Honor, I apologize. I didn't. I put the invoices in there, but I didn't. I should have put a little Excel sheet, and I didn't do that.
Okay, so initially, I heard you say that it cost you $1,900 to remove the existing water heater. To replace it, you purchased one for $1,800, and to install it, it was $2,000. Those are the numbers I heard.
Yeah, and there's the $2,000. is the installation labor for the water heater. The replacement water heater itself is 1,800 and change. The removal of their system was $1,949.
Okay.
And the initial installation of that system was $3,282. Those four items are the damages, which totals $91,2535.
The initial installation, one more time, was how much?
Sure, Your Honor. $32,82.40.
Okay. And then 1949 to remove it, 1,800 to replace with a new unit, and then 2,000 to install it.
Right. And the new unit itself is just the water heater, which is totally separate from what I was purchasing, which was a water filtration system. The water heater was damaged by their high
Yeah.
pH from their filtration. Okay.
And the 3282.40 was the installation of the water filtration system.
That's correct, Your Honor. Yeah. And then over and above all of that, I'm not claiming the cost that it took to install a replacement water filtration system or the cost of that system and labor itself, of course. And I'm just trying to put myself in a position I would have been but for the misrepresentation.
Okay. All right, I'll hear from iSpring first.
Yes, so there is a disclosure in our product warranty that states the pH level could increase with the installation and use of the product WCFM 500K. I do have an exhibit. I was wondering if I could screen share.
Yeah, screen share. Okay, apparently you can't.
Oh, not a problem. I can definitely send in the exhibit after, but in our product warranty on page 4, it states that the water pH range is between 5.8 to 10.8, and the actual performance of the system can vary based on the local water conditions and quality. And basically, the variation depends on each customer's local water condition, such as mineral content and source of water chemistry, which is outside of our control. And the plaintiff reported pH is within this disclosed range. I believe he stated it increased from 7.88 to 9.59. And our product warranty, we stated 5.8 to 10.5.
Okay, and in the warranty that was in existence at the time that Mr. Pravatsky purchased the system, or one that was subsequently added?
Yes, correct. The one that he purchased, because every one of our products, it comes with a product warranty.
That was not provided to me, Your Honor.
Okay, and Mr. Lynn, how does the purchaser of a filtration system become aware of the product warranty?
Yes, well, when you open up the product, the warranty is basically in the package with the product. So it's the first thing you see when you open up the package.
And the package being what? A plastic bag of documents that comes with the filtration system? How does Mr. Pravatsky see what the warranty is?
Yes, so it comes in a plastic bag, I believe, and it should be like on top of the system when you open it. It states whole house WCFM 500K, whole house central water filtration system, installation instructions and user manual.
So the item sold through Lowe's, the warranty is in this bag that's on the filtration system. When Lowe's delivers it, is it your expectation that the bag is there? Or, how does that get from iSpring through a vendor to the customer?
It will be shipped in the box for the product, and it will be, physically inside the container.
Okay, so the shipment goes not through Lowe's. It's not this isn't an off-the-shelf purchase. This is something that is purchased through Lowe's and you ship it to the customer. Is that what you're telling me?
I believe Lowe's has it in their like warehouse.
Your Honor, if you look at my exhibit, it shows it was shipped directly from iSpring. Lowe's is a consignee, but it comes from Cumming, Georgia. I can give you the exhibit number if you need it.
Oh, I see a bill of lading, tracking. Is that what you're talking about?
Yes, Your Honor.
It shipped on the 2nd of December from Cumming, Georgia. Would that be an iSpring warehouse, Mr. Lynn?
Yes, our warehouse is in Cumming, Georgia.
Okay. Now it says delivered to Olympia, but it doesn't have an address. Is that being shipped to Lowe's? So I looking at that document, I can't tell who was the recipient. Is it whether it's coming to you directly, Mr. Pravatsky, or to Lowe's?
It did come to me directly. I think on the delivery receipt it shows, but I can't say for sure, Your Honor. I'm not involved in that process, the shipping itself.
Your Honor, I don't mean to interject. On the bill of lading, it has Mr. Pravatsky's address in Olympia, which is where it would have gone.
Okay, yeah, I see that now. Okay, so as to this particular filtration system, it appears that we skip Lowe's. It goes, the order was placed. I don't know whether it was placed through Lowe's or not, but the order was placed and then shipped from iSpring directly to Mr. Pravatsky is how it appears. Okay, Mr. Pravatsky, Mr. Lynn indicates that on all their systems, they have the warranty information. Are you telling me it wasn't there? Or you didn't read it, or what?
I didn't see it. I opened it with the plumber when the plumber was here. I didn't see anything that said anything about not drinkable or not or high pH. Nor did the representative point that out when I was making the purchase. Which if the EPA's fact of high pH causes deposits isn't clear enough, that they should point that out when the consumer is investigating the determination of purchasing their product. And then they, after the fact, update the Lowe's website where I purchased it to actually include this 8 to 10 pH range, which wasn't there when I initially purchased it, which you can see in my exhibits. That leads me to believe that there's some questionable activity going on.
Okay, so Mr. Lynn, other than in the warrant, so you're indicating it was available in the warranty package. Mr. Pravatsky says he didn't see it, but you're telling me it's provided with every filtration system. Is that correct?
Yes, that is correct, Your Honor.
Okay, and do you make notice of it in any other form? Or is it just in the paper warranty packet that's provided to the purchaser?
Yes, it is in the paper warranty package provided to the consumer. And I believe it should also be on our website. Because if you visit our website and you scroll down, there's also like information about the product itself.
Right, and does it have the pH range from 5.8 to 10.8 in there?
That I would have to check. But yes, we do include like explicit like information about each system on our website.
Okay. Specifically, you're relying on the warranty language that says pH is acceptable. pH is 5.8 to 10.8. Is that specific language included in the website information on the product?
Please give me a second, Your Honor. I'm pulling up
Sure.
our website. Because I'm not in charge of our website, so our developers are actually like updating it. Okay, Your Honor. So while it does not specifically state on our website itself, we do have the product manual on our website for the product. So if you click on it, you can see the pH level and everything that's specifically stated with the product itself.
And that product manual that you've referred to, which had the warranty range between 5.8 and 10.8, was available to Mr. Pravatsky prior to the time of his purchase?
Yes, correct.
Now, Mr. Pravatsky has indicated that he believes that Lowe's updated their website to show some change in the pH information that existed prior to his purchase and then subsequent to his purchase. Did iSpring make any change on its material subsequent to Mr. Pravatsky's purchase that you're aware of?
Not that I'm aware of, because I believe all information about the products are already updated on the Lowe's website. And if anything were to update, that would go through our marketing team.
And since Mr. Pravatsky's purchase of this and then alerting iSpring that he was having an issue, do you know if iSpring has put out any sort of warning about high pH impacts?
No, because it already stated in our product warranty that the pH level would be from 5.7 to 10.5.
Okay, so your answer is no. iSpring has not put out anything in response to the issues raised by Mr. Pravatsky's communication with iSpring.
No, Your Honor.
Okay. And Ms. Tisch, what was Lowe's role in all of this?
Lowe sells the product. This is, from my understanding, an online purchase, which is how it becomes a direct ship from iSpring. You didn't walk into Lowe's and say, I want to purchase this. Seems like it was an online purchase, not something he came into the store and purchased and took home with him. It was a direct ship from iSpring. And when he returned the product, March 7th, he was issued a full refund for everything that he had purchased.
And full refund in what amount?
I believe that's in my documentation. He was given back that total. 30 grand total looks like it was. You'll have to look. That was his purchase. He was refunded. Oh golly, 36.98 and 86 cents.
Okay. And
Exhibit D2 shows the total refunded amount.
Okay. And the refund was because Mr. Pravatsky had indicated to you that he wasn't satisfied with the filtration system that had a pH that went up to 959. Is that why the purchase is refunded?
They don't always note a reason, just says not wanted or defective, not needed. But the store doesn't necessarily look into reasonings why. Somebody comes back and brings it and says, hey, this didn't work for me. They can mark it as defective.
Okay. And Mr. Pravatsky's indicated that Lowe's has made a subsequent change to its website regarding the product. Are you aware of that he's indicated?
I am aware that he has indicated that. Lowe's gets the information for its various products from the manufacturers. They update the information. They provide it to us. Lowe's does not generate the details or the information about the product. It is simply attached to the product and just posted. Some vendors are actually able to upload that automatically themselves. I'm not sure of the exact details on this one, but all the details and information regarding the products, any warranties, all that information is provided by the manufacturers.
Do you know what warning Mr. Pravatsky is referring to when he says on the Lowe's site there was an updated warning?
I wouldn't call it a warning. It just has a note. He had some documentations that say it shows the pH could be between 8 to 10.
Okay.
I wouldn't call that necessarily a warning. It doesn't say warning, your pH could be X, Y, or Z. It just says, here's the range.
And Mr. Lynn, if that came from iSpring, do you know when that was added? Mr. Pravatsky saying it didn't exist at the time of his purchase.
I am not directly the one who's responsible for sending the information to Lowe's or updating website, so I can't
But
say.
you don't have any way of looking at, are you acknowledging that it's there on the website? Is there something there that you provided Lowe's that they would have that in the product description?
Yes, I believe it was already on the Lowe's website. Or maybe somebody from the marketing team maybe heard about it from the customer service team and updated the website.
Okay, so it's possible that Mr. Pravatsky's accurate that it wasn't on the website at the time of his purchase and was subsequently added when subsequent to his purchase. So that's possible. Are you indicating that?
Yes, it's possible.
And Your Honor, you can see that in my exhibit 5 and 6.
All right, looks like I don't know where you got the information, but it says last modified on the 7th of February, 2025 at 14:38 or 14:30. Looks like maybe 14:30 hours.
Yeah. And if you look up from the left of that, that shows it came from Lowe's.com product images.
Okay.
I'm sorry, you're saying you got that from Lowe's, that information, those details?
That's from Lowe's website.
I don't believe our website provides information on its actual updates. I would have to look at that, but
Yeah, this is in the code behind the website, which is visible to anyone with a browser to show the elements in the page. I would have loved to get it from Lowe's, but you guys refused to provide it.
So your exhibit 6, Mr. Pravatsky, just shows a photo of the filter, doesn't have the information that was on your exhibit 5. Are you telling me that it was just a picture of the exhibit and nothing else, or of the filtration system?
That's correct. And if you look at exhibit 4, you can see that's how that one image to the second one on of it is how it's displayed at that time. That's what the image is there. That's what I was presented with when I purchased the unit. And exhibit 6 is the best I could find of the representation of how it was displayed to me at that time. But 4 is the actual page. And I printed that out, as you can see at the top, February 6th, which is before Lowe's or iSpring made that change, which was on, what was that, February 7th? Yeah. So that is the image of how I saw it when I purchased it, at least to the best of my recollection.
Okay, so it appears in looking at your exhibit 4 that the website's silent on pH issues. And then
Correct, Your Honor.
February, it's updated to show the pH levels 8 to 10.
That's correct.
And that's your argument, is that the website should have had that information at the time you purchased the product.
Yes, sir.
And you're saying that, understanding that Mr. Lim said that regardless of what was on the website, you received with the packet a manual which would have told you that it was at 5.8 to 10/8, and that if you'd gone online to do, you could have read the manual online prior to purchase and seen 5/8 to 10/8. So any comments on that?
I disagree that that information was there. I'm certain I would have seen it. But that's the best, you know, the fact that they're retroactively modifying this image on Lowe's just leads me to believe that they feel culpable, but they're trying to hide it. But I don't know, Your Honor. All I know is their product. They should have pointed it out. It seems like it should be more blatant than hidden, if it is even in these supposed documents. And then, you know, in turn causing this damage. So they're retroactively trying to change that information.
Mhm.
May I ask a question, Your Honor?
Yeah, Ms. Gish, just a second.
Absolutely. Thank you.
Yep. And Mr. Pravatsky, what's your belief as to Lowe's liability in this case if all they're doing is updating their website to reflect information provided by the maker of the unit?
I do understand that, Your Honor. I think under RCW 7172, the Washington Product Liability Act, retailers can be liable for defective products and failure to warn. I feel like
but
it falls
they would
under
have
that.
to know that there's something to warn about, right?
You know, I'm not a lawyer, so I would have to look. But
Okay,
yeah.
Save that for the Supreme Court.
No, thank you.
Okay, Mr. Lynn, anything else?
Yes, I did have a question for the plaintiff. How did he have a sample taken like 4 days prior to getting the refund, and you know, also got the results in time and get someone out there to remove the system? And each test was also like in a different area, so there's nothing to show a comparison of like the raw prior to install and raw after. And I also was wondering like you know, if there was an invoice for the removal of the system. And if that's like the invoice from March 10th, then how did the plaintiff get a refund prior to it being returned?
A few questions for you, Mr. Pravatsky.
Yes, Your Honor. The collection date was March 4th. As you can see on the representative sample there, the original, what do you call it, pH result was retested prior to the filtration system on February 6th, and then tested post. And then if you look at the removal invoice, that is March 10. So those all fall in line, Your Honor. I'm not sure what the
All right, so
iSpring's implying.
what's your basis of claiming liability for the original purchase when that was refunded by Lowe's?
Oh, I'm not, Your Honor. I didn't, that's not part of my claim. The purchase price of the original equipment is not part of the claim.
So the claim is the removal of the water heater, the replacement of the water heater, and the install on the water heater?
The install of the water filtration, the removal of the water filtration, and the water heater, and the water heater labor replacement.
Okay. So the install of the water filtration system isn't your original cost for the iSpring. It's whatever product you have in there now that you paid $32.82.40 for.
No, Your Honor, that's the labor to install the iSpring. So the iSpring equipment itself, Lowe's did refund that. that cost, the 3,200, is to install the iSpring.
Okay, so you received a refund from Lowe's for the purchase price of $36.98.86. You had costs in installing that product, and your costs were $32.82.40. Is that right?
That's correct, Your Honor. And then another cost to remove that system, and then a cost which I'm not claiming here, which was to install the new system.
Right. Okay. So and then the removal of the water heater, which you believe was damaged because of high pH, was $19.49, and you replaced the water heater for $1,800, and you installed the installation labor was $2,000. Are
Correct,
those?
Your Honor. Yeah, the bottom line is putting me in the position I'd been had I not purchased the iSpring in the first place. Had I gone with this other manufacturer,
Yep.
I'm not including any of those costs.
All right, and Ms. Kish, you wanted to add something?
Yeah, I wanted to get clarification on this water sample. And just a timeline from the water sample that was collected March 4th, and it appears it was received on March 10th. So that would be received by the lab on March 10th. And then the report was on March 17th.
That's correct. That's the process. You mail it into them. Yes.
Okay. But you received your refund for the iSpring on March 7th, which is before this sample was even received.
Correct. I did. If you'll see in the chat that I have with iSpring, I have a manual tester, and I tested it manually, seeing the high pH, and then I knew I had to send it off to ensure, because those tests can be inaccurate.
Okay,
And
but we
so I
don't have
took
any
the sample.
documentation of a sample that was. We don't have any documentation showing that. I guess, do you see what I'm saying? Like, you're saying there was something that indicated that, but I see this as you didn't even know what this, there's nothing documenting what the actual level was until a sample was taken essentially 4 days before you claim it was removed, and you had it removed before you got the sample results?
Well, yes. Yeah. Yeah. The I don't understand your point here. The point is the sample was taken through that system. Then it was determined I needed to remove that system. I didn't wait for the actual results from the testing facility, because that takes time.
But you
as I
didn't
know it
provide any
does.
documentation of what it was, so we don't know.
You wanted me to, well, I don't need to. It's the lab that does the actual work. Who would rely on my test? Nobody would want to look at my test.
So it's just, you're just saying you took a test. We don't know that. We don't have any results that you can show. So it was removed after.
I'm still not getting your point, ma'am. I
Okay.
took the test before removing the system.
So the initial pH level that you'd indicated of 788, was that your manual test, or was that some test that you had sent out to a lab?
No, Your Honor, that's also a lab test.
That was a lab test, and so
Yeah,
that was
if you
your
look at
pH.
it, that's the
prior to
pH
purchasing?
from our well. Yeah, pH from our well is 788, and that's Exhibit 8.
Okay, but that's a lab result, not a sample result that you had taken.
A manual result of mine? No, I didn't take my own individual. I mean, I did, but
Okay.
I didn't document that.
Okay,
Figured the lab result was what really mattered.
and the lab result of 788 was on what date?
That was collected on February 6th, received on February 10th. That's, as you look through my notes, you can see that's when I had the concern started. And I opened this issue with both Lowe's and iSpring back on that date.
But you didn't take samples from raw water and filtered water on that date.
I didn't think I was going to have an issue with the manufacturer Lowe's doing what they did, changing the website or refuting the.
I was just
Okay,
asking questions.
okay, all right, hold on. Okay. So you did a water test on 2/6/25, and that result eventually came back as 788.
That's correct. And that holds true, but I could show you the water test that when we purchased the house a few years earlier, the water test we do every 6 months. That holds true. That number is constant
Okay,
for our well
so
water.
what about that return number 788 caused you to start communicating with iSpring?
No, it wasn't that return number, Your Honor. It was the individual test that I had done.
Okay, and that test showed what level? Is that the 959?
No, Your Honor, that's the lab test. I don't
Okay.
know offhand what the number was, but I knew it was outside of the acceptable range.
Okay, so sometime after your February 6th lab test result, you then took your own test, you saw a higher number, and you contacted iSpring.
Both, yes, both before and after. I did this lab test to ensure that our water pH had not changed in the 2-ish years that we'd owned the home. So that's the February 6th test that I did, just ensuring that nothing changed on my end. Then I started communicating either just before that or around that time with both Lowe's and iSpring, saying, hey, the pH seems high or is high based on my basic test. Is this common? I went back and forth. And then after not getting any resolution from them and finding out that the only way to resolve it was, or that the level was too high and it was probably causing other damage, was when I then tested and returned the product.
Okay. So the the 788 number came from a collection on the 6th of February. Yes?
Yes, Your Honor. Yeah, it's in that report right there.
So it looks like, based on what you provided me, that iSpring updated its website information on the 7th of February. So before you knew the results, and you had not yet reported any defective system to iSpring, is that correct?
Let me confirm the date I did, Your Honor. I don't offhand recall the date I made the report initially to iSpring, and I think it was before that. Yeah, my pH levels email to iSpring is January 28th, 2025.
And that's just based on a test you took?
Yeah, which they're not completely reliable, and that's why I sent it out for testing. But before doing that, between January 28th and February 6th, 1, 2, 3, 4, 5, 6, 7, 8 emails with iSpring going back and forth on pH, asking if that's an issue, is that a concern, telling them that my pH is 959. And after that point is when I determined, okay, they're going round and round. I need to test my original water just to make sure nothing has changed. And that's when I did the direct well water test that's without any filtration.
Okay, so you started communicating with iSpring about the pH, your pH concerns at the end of January.
That's correct, Your Honor. January 28th, 2025 at 5:02 a.m., 5:20 a.m. Pacific Daylight Time.
All right. Mr. Lynn, do you have anything else?
Yeah, I wanted to add, since the plaintiff installed the system, I think in December, and he found out the high pH level in January, and I wanted to say that like that time period, a month, that's usually not natural for pH levels to rise that high, because hardness, it refers to like the concentration of the dissolved minerals, which is like mainly calcium and magnesium, which contributes to like scaling, and that leads to like the pH level. However, that usually happens because of like the local water, not because of a water system that you install for like a month, because that doesn't like raise the pH level that high. And additionally to the claims for compensation related to like the installation costs of the products, or any allegations seeking compensation for like the water heater replacement, replumbing or otherwise is precluded by our limited warranty outlined in the product manual. So our limited warranty specifically has a clause that states that, iSpring, since we're only a distributor, we're not a manufacturer or installer, we don't cover the cost of installation or reinstallation of any products.
Okay, Mr. Pravatsky.
Your Honor, the misrepresentation of this being a system that works for wells, not pointing out the fact that the pH levels can rise, and they did. There's nothing else that would have made them rise, and that's specific to the lab tests, which, as I said, and I have proof of, the pH level of our well water prior to filtration has not changed from the day we bought the house. 788 has been constant. So iSpring is looking for an out when they should be telling customers explicitly, and then they retroactively changed Lowe's website to tell customers 8 to 10 pH when they should have pointed that out initially when I purchased the system clearly, so that I didn't run through this.
What do you contribute the increase in pH to?
It can only, from my perspective, be attributed to their system. After we replaced it with another system, the pH is normal.
Normal meaning 788.
It's I think it's 7.5 actually. It brings it down a couple little points because it does a better job of filtration.
All right.
I have that test if you need it, Your Honor, on the new system.
And Mr. Lynn, you indicated that the warranty language does not cover installation costs. Is that correct?
Yes, that's correct, Your Honor.
I'm going to find in favor of Mr. Pravatsky as to iSprings. I'm going to dismiss Lowe's. I don't find any basis for a claim against Lowe's. So I have dismissed the claim as it relates to Lowe's since they just provided the information on the website based on that provided by iSpring and had no notice as to why they shouldn't do it. So they are dismissed as a defendant. As to Lowe's, or as to iSpring, the change on the 6th of February to adding the pH to the website, which was the one change to that website from the way the website was designed prior to the purchase by Mr. Pravatsky. And then about a week after he started raising issues of pH with iSpring, maybe coincidental, maybe not. It does appear that that added information was put there to address the issues that Mr. Pravatsky was raising. That would be, since this was an online purchase, the use of the website would be appropriate by Mr. Pravatsky in reliance on that and requiring him to read the product manual to find out what the acceptable pH ranges for the filtration system, I think go beyond what we would expect consumers to make. So I'll find judgment for Mr. Pravatsky for the damage to the heater, removal, replacement, and installation as a result of the high pH. And the principal judgment would be $5,749. I will not give him the installation of the subsequent filtration system since that was precluded as part of the warranty. Total judgment, $5,808.68 as it relates to iSpring. All right, thank you all.